For now,
So the last month.
1 second. What?
All right. Good afternoon. For the record, my name is Jonathan Kwan. I'm the chairman of the Criminal Law and Procedure Review Commission. We are here for a plenary meeting of the commission. It is now 12 p.m. April 4th, and this meeting is now called to order. I note for the record that we are in person in Judge Joaquin V. Manibusan Senior's Memorial Courtroom in the Judicial Center. We are on Zoom for those members who are not able to attend in person. We are also live on the Judiciary's YouTube channel. As this meeting is being recorded, to avoid background noise, I ask the members appearing by Zoom to please mute yourselves unless you are speaking. And if you are here in person, please wait until we position a microphone before you speak. Please put slide 2 up. Here's the agenda. On agenda item 2, due notice. I note for the record that due notice of today's meeting has been provided pursuant to the requirements of the open government law. Copies of the newspaper notices are included in your packets. On agenda item 3, quorum. We'll start with the roll call. Members who are here, when your name is called, please state present and the location you are appearing from. May I ask our CLRC research assistant, Renee Meno, to please call the roll.
Honorable Jonathan R. Kwan.
Present, Judiciary Guam.
Honorable Maria T. Senzani. Honorable Anita A.
Present here in Tom Home.
Attorney William Buffy Brennan. DOC Director Fred Verdalio.
Present Judiciary One.
Chief of Police Stephen Ignacio or designee Lieutenant Ron Teton. Attorney Joseph B. McDonald.
Present at McDonald Law Offices in Agana.
Attorney F. Randall Cunliffe.
Present on Zoom from Agana.
Mr. Monty McDowell.
Present from my office in Harmon.
Attorney Stephen Hattori or designee Attorney John Morrison. Attorney General Douglas Moylan or designee Assistant Attorney General Stephen Cody.
Present from the on Zoom from the AG's office.
Attorney Michael Phillips. Ms. Valerie Regis. Attorney Christine Tenorio.
Present via Zoom at my office at the ITC building in 20.
Attorney Philip Tydenko.
Here in the court building.
Ex officio members, CLRC Executive Director Serge King.
Present.
Compiler of laws, Jerry Cepeda.
Present at the judiciary.
Mr. Chairman, there are 8 commission members present.
Mr. Executive Director, do we confer that we have quorum?
We have a quorum, Mr. Chairman.
Thank you. We ascertain that we have a quorum and can conduct the business of the commission in this meeting. Do we have any other guests? No, right?
No other guests.
Okay, thank you. On agenda item 4, the minutes, we have the plenary meeting minutes of February 29th, 2024 for approval. These minutes have been provided in the meeting packets for the board's review. May I have a motion to approve?
I move they be approved as written.
Thank you, sir. And is there a second?
Second.
Any objections? There being no objections, it is passed. Thank you. On agenda item 5, may I ask the executive director to address item 5A?
Thank you, Mr. Chairman. This is a informational item. I'd like to first start to remind everybody that your first quarter progress reports are due. Please submit them by April 19th. We'd like to submit the final report to the Governor, Speaker, and Chief Justice by or before the end of April. On the subcommission chapter status updates, work continues diligently by all subcommissions on their assigned chapters. However, we do have a large number of chapters left to review. We recognize the difficulty our members have in finding time to review the chapters, and we encourage all subcommissions to work diligently. Any need of any kind of support, please let us know, and we'll get right on any such requests. to expedite review of chapters, the Criminal Procedure Subcommission has taken on chapters 1, 4, and 7 of Title IX. We will be presenting chapters 1 and 4 today. Chapter 7 we'll present at a future plenary meeting. That's all I have, Mr. Chairman.
No, what about the set reviews of GCDO?
Oh, okay, sorry about that, yes. I apologize. The commission has sent a review request to the Guam Election Commission, the Department of Labor, the Department of Revenue and Taxation, and Public Health and Social Services. We've asked these departments to review the criminal statutes that affect their agencies, statutes that they are charged with enforcing, and statutes that create criminal penalties. We've heard back from a couple of agencies that they're on it and currently reviewing these statutes. And we will report back from whatever information we see from these agencies to the responsible subcommissions.
I have a question. Serge, you mentioned chapter 4, which is general principles of liability. I know that it appeared that it was initially assigned to the subcommittee for crimes against property. So should we just skip that then? We can. I'm looking at the old assignment.
Okay.
So you folks are taking on 4. I'm sure there's no objection from Randy and Monty and Bucky that we let you guys tackle that, but that doesn't mean we can't chime in on it.
Of course, we welcome it.
That's fine. I think we've covered most of it today. We'll present recommendations on it, and if any subcommission, if you have anything to offer, Bill, then please let us know. If the commission prefers to table it for further review and discussion, we can also do that.
Okay, well, I'll check back with Randy and Monty and Bucky, but I'm pretty sure that we don't mind being one chapter short. But of course, if we're interested, we'll chime in
Please,
if we've
please do.
done stuff already. If that's okay with Monty and Randy, I know they're on, so I don't think they'll object, but who knows? Thank you.
No objection.
Okay, great. Thank you, Monty.
All right, thank you, Mr. Executive Director. Put up slide 4, please. At this point, we were supposed to hear from the DOCO subcommission report today. Due to several unexpected circumstances, as well as some personal issues with some of the members, they were unable to complete their meeting and work. So we will table this item until our next plenary meeting to allow more time for DOCO to review their chapters. Those of them that are experiencing some difficulties, we wish them well. Under item 6B, we have the presentation of the subcommission on criminal procedure. Madam Chair, Judge Sicola, you have the floor, ma'am.
Good morning or good afternoon. I hope you can hear me and see me. We are ready to present, I believe, for today with Serge leading our team in our review of chapter 1. Is that correct, Serge, as well as chapter 4? Or are we still going to do strictly 4 today?
Yes, Your Honor. We'll do chapters 1 and 4 today.
Okay,
I'm
so
ready.
very well. That's what we're going to be presenting. We've met for a couple of weeks, 2 or 3 weeks in this last few past weeks, and we came up with the following that Mr. Serge King is going to present. Thank you, Serge.
You're welcome, Your Honor. It's my pleasure. Next slide, please. Okay, as we said, we'll be doing chapters 1 and 4. What you have before you is chapter 1, entitled Preliminary Provision and Definitions. And starting with the first section in chapter 1, section 1.10, short title. Basically, we're cleaning up the section a little bit, making it a little bit easier to understand, and also making it consistent with the first section in Title 8, 1.01. Basically, we're just saying that this Title 9 of the Guam Code annotated shall be known as the Guam Criminal Code. We are suggesting removing the word correctional unless there are any strong objections. I don't think that this changes the title in any way, but it does kind of streamline the title and brings it in line with most of the other jurisdictions whose criminal codes are just known as that, the criminal code, the penal code, and so forth. We're also adding a short definition of code, capital C, as used in this chapter to refer to this Guam criminal code, just to avoid any conflicts or confusion. Any questions on this one or? Okay.
Any comments? We're gonna go this one by one or all at the end. What do you want to do?
We'll probably go through it, and if there's anything, then we address it.
Would it be confusing? Sorry, Jerry Cepeda. Would it be confusing if we used,
Come on, say it. Say it. If you use what?
if we use code to refer to this criminal code, because it might, people might be confusing that with the GCA, Guam Code Annotated.
That's a good point. So I think when you just simply shorten it to code.
Could we say this code?
There's still references to civil code. Through some of the statutes, and there's reference to, like you said, the Guam Code annotated, so.
Well, the reason why we have this is because if you notice at the beginning, it said this code, capital C. So we kept the capital C in the last sentence there, so that it actually creates a name for what we're referring to.
At the time it was, when it was a separate criminal code, could we somehow tie in Title IX of the GCA? As an additional, this criminal code, also Title IX of the Guam Code.
Oh, I see what you mean.
You see that to clarify what it means.
Okay.
Okay.
Yeah, we can work on that. We'll submit that to the plenary commission then. You have a specific suggestion?
Just to refer to Title IX of the GCA, because code, we know as users means the criminal code Title IX, but the average person may not. They might think it's something else.
So what we have there, this Title IX of the Guam Code annotated shall be known as the Guam Criminal Code.
Or code as used in this chapter refers to. Okay, maybe not. No, I see. No, never mind.
Right.
It makes sense. Title IX.
We hesitated to use the word code in general for other chapters because it's used so widely. The word
Yes.
code is used so widely. But in this chapter 1, the word code with a capital C is actually referencing this the Guam criminal code specifically.
No, that makes sense. Sorry. It's fine.
Okay.
It's fine.
Okay, then I'll move on to the section.
This is Randy. In the code itself, it refers to other codes. So it's just in chapter 1, it says in certain places, if it's defined in any other code, and if you're saying code means this chapter or this code, that doesn't conform with what the statute's saying.
Is the word code capitalized or?
Yes, it says, or a statute other than this code enacted, and it says that several times throughout the chapter.
Okay, then we'll go back there. Maybe we'll just strike the last sentence.
Yeah,
Mhm.
that might be
Yeah.
easier.
Okay, then we'll strike the last sentence if there's no other.
I think that's the easiest way to.
Check it out.
All right, then what we'll have to offer is just the first sentence there. This Title IX of the Guam Code annotated shall be known as the Guam Criminal Code.
Yeah.
Period.
Any objections at this point on that?
No.
Okay,
Okay,
next one.
all right, thank you, Randy.
Thank you, Mr. Garland.
Section 1.12, we're recommending striking this section, but we're actually going to be consolidating this severability section into a new reenacted section 1.12, which you'll see in a moment. Next slide, please. So this is the new reenacted section 1.12, which is entitled Rules of Construction. And it consolidates several sections from this chapter. The comment shows that it It includes sections 1.12 severability, 1.34 rules of construction, 1.36 headings, and so forth. So all of those sections have been moved into this one rules of construction section just for to make the chapter easier to read. We believe put all the definitions or all the rules of constructions into this one section without change. I'll add.
Where did you get the other sections, the other language?
Oh, they're the different language.
Okay, so under the current 1.12, this is
Right.
Jonathan Kwan.
Right.
Under the current 1.12, it's one paragraph.
Right.
I'm noting a lot more verbiage. Where are you getting B, C, and the rest?
Here,
Where's it
BC
coming
are
from?
Down below the
sections down
comment.
below.
under the comment,
I see, I see,
1.34.
I see.
So they just, this is just consolidating these sections here.
You're consolidating 1.34, 1.36, 1.38, 1.42, 1.44, 1.46, and 1.48.
Right.
I'm assuming you're deleting those from the,
Yeah, they're gonna be stricken as you'll see later on.
I see. Okay, I got it.
Okay. All right, moving on then. Next slide, please. 1.14. For this section, we are proposing to clarify the title, the original title, purpose for defining offenses. We're taking the actual title from the model penal code and putting it back into this 1.14 so that it embraces what we believe is a better description for the entire section. We are also recommending to add 3 new subsections to B, subsections 8, 9, and 10. And as you can see, subsection 8 to promote restitution to victims. We've taken this from the New Jersey Criminal Code. Subsection 9 to provide the defendant with needed educational or vocational training, medical care, or other correctional treatment in the most effective manner. We've taken that from the United States Code. And subsection 10 to impose sentences no more severe than necessary to achieve the societal purposes for which they are authorized. And this is from the ABA standards of what's it called here? Criminal justice. We believe that these sections, like the restitution section, for example, is consistent with chapter 85, I believe, of Title 9, which provides for restitution.
85.
9. That's also consistent with other parts of Title 9, and I'll also add that it's consistent with the new correctional medical clinics section that was proposed at the last plenary meeting.
I'd like to note for the record that Attorney John Morrison from the Public Defender's Office is present. So that brings the number up to 9. Thank you. Please continue, Mr. Executive Director.
And subsection 10 is consistent with the overall. It's consistent with the overall purpose of this section, specifically B4 to safeguard offenders against excessive, disproportionate, or arbitrary punishment. So those are the questions. We're also correcting a typo in main section B.
Subsection B.
Right.
Of offenders.
Sentencing of offenders.
Any questions or comments on this?
This is Jonathan Kwan. I do not have any objection to the additional language and the correction or revision. My only question is, and I'm not opposed to it. What was the impetus for inserting 8, 9, and 10? Just
To be consistent.
Well, to be consistent and to add more to it, we think
Yes.
1.14 was originally added when the statute was passed by the legislature in the 70s. And it is consistent with some of the more recent chapters in Title 9 on restitution.
Okay. For the record, thank you.
You're welcome, Mr. Chair.
Any objections, any other comments?
It just popped out, Phil Tidico, on number 8 to promote restitution to victims. Is it in Title 8 or Title 9 where the victims of crime bill of rights is
That's
in
it.
there and
Mhm.
9, it's okay. And I wondered whether some of the rights there should be mentioned along with number 8 to promote restitution and whatever the rights there contained therein. You know, I think those are more notice rights. If I recall that chapter one, I think it's section 161 or something. Maybe Christine can help me out, but I think a lot of it's designed to be more notice. Victims have a right to be notified of this, notified of that. Just wondering if you're gonna put to promote restitution victims, it might be as well as to promote the notice requirements for victims, you know, under, you know.
This is, I think, a general
Purpose
purpose of
statement, yeah,
construction
okay.
with the.
I just wanted to add that thought in there in case somebody wants to push it, so. But if I recollect that statute, it was mainly
Right,
a notice rights type of chapter.
yeah,
So,
that,
okay.
that does provide victims with the right to be notified.
Yeah, like at different stages, yeah, so,
I'm not sure if it's necessary in this with the general purposes of
Yeah.
construction.
okay. Anyway, just wanted to get our thinking about that.
Okay,
All right, but I'm good with it the way it is. I'm glad you have promoted it. We should for sure that
all right.
and there's a whole fund dedicated to that anyway.
There being no other comments,
Okay,
One quick, just typographical comment. This is Assistant Public Defender Brian Eggleston, an ex officio member. I only just now noticed that in order to make this grammatically correct, we would need to strike the "and" at the end of subsection B6, change the period at the end of subsection B7 to a semicolon, and then 8 and 9 should also be semicolons with an "and" after 9.
Oh, okay, all right,
Correct.
all right, good catch, Brian. Thanks. We'll make those changes.
okay.
good eye, thank you.
Okay, next slide, please. Section 1.16 territorial applicability. All we're doing in this section is removing the word territory and replacing it with Guam, which is consistent with the requirements of one Guam Code annotated section 4.20. 420, I'm sorry. Next section, please. This continues with the same section. Yeah, continues with the same section 1.16. More of the same types of changes, replacing territory with the word Guam. Next section, next slide, please. Same thing here in 1.18, classes of crimes. Suggesting no other changes other than to remove territory and substitute in Guam. Next section, next slide, please.
Yeah.
Same thing goes with 1.19 and 1.20. Just changing territory to Guam. Next slide, please. And again, the same here. We're actually in 1.24, a typo correction, adding the word "bin" where it was not inserted. And in 1.26, we are simply a citation clarification to make it a little bit easier to understand. But no other changes other than this.
I see. Any comments on these suggested changes for these sets of statutes?
Next slide, please.
Thank you. There being none.
Okay. Section 1.28 concurrent jurisdiction when a bar to prosecution. And it might look like there's a lot to be changed here, but in the first paragraph, we're just changing the word territory to Guam. In subsection A, what we've done here is we've moved the subsections 1, 2, and 3 from the way they were formatted and brought them into the paragraph. We thought that it read a little bit easier, which it may not be so intuitive, but the format here follows what was in the model penal code And to us, it seemed easier to understand when we had it in this format. None of the language was changed. Basically, just a formatting change.
Let's see. Yeah, but what happened to number 3? Oh, I see, it's there, it's the
Number 3
last,
is-
it's there, okay. You just put them all together under
All-
A, yeah. Okay.
Any other comments? Any?
Next slide, please. 1.30, citation clarification in subsection B and a grammatical correction in the first paragraph. Next slide, please. Okay, so here we've got sections 1.34 to 1.48, and these were the rules of construction. They're stricken here and have been consolidated into the reenacted section 1.12 that you saw before.
I see.
Next slide, please. Okay, and here we've got 1.50 military authority. And we had a bit of discussion on this. We had initially thought that this was a remnant of the old Guam Penal Code, and maybe because of the naval civilian government here, and then the naval government, and then the civilian government, we thought that this might have been a remnant from that time. But when we reviewed the criminal codes of other states, we found it in at least Arizona, Nevada, Utah, and California. And so there is a purpose behind this, which is not unique to Guam. So we figured we'd leave it here. I'm not sure, Mr. Chair, if you have any thoughts on this as a JAG officer.
This needs to be left in because it does. Guam currently does not, the Guam Marine National Guard, for instance, does not have the ability to, does not have the mechanism to prosecute or commence court martials. But that can and will be in place at some point.
Okay.
Additionally, so it needs to be not touched, this needs to be left as well. Additionally, there does cause some. It needs to be left so it doesn't interfere with the other branches, the other military branches who may have concurrent jurisdiction.
Okay.
So that's fine, please leave it in.
Okay. Questions, comments on 1.50? All right, moving on to 1.60 general definitions. We're of the thought that these definitions are not necessary. They're probably self-explanatory throughout the chapter and the title. We did wonder if the last definition for person was also necessary or should be kept. But in the end, we decided it probably isn't necessary as the criminal provisions dealing with corporations are located elsewhere. And they're probably pretty self-explanatory. If it becomes an issue upon review of those chapters, then we could revisit the definition of person.
This is Randy Cunliffe. I just note that the section F that talks about person or natural person, etc., was added by Public Law 16-84. Did you look and see why that was put in? Was there any court cases that had an effect because that wasn't in the code? They threw it out?
Yes, actually, Randy, we did look at the public law that enacted that. And this subsection, if you're right, it came after A, B, C, D, and E. But there was no indication and it was just slapped in as a part of that particular public law. But there was no other legislative history or any other reasoning for them to put it in there. And the section F, if I recall correctly, it didn't really have anything to do with the other parts of the public law.
Randy, do you think was that around the time when they were looking to revoke some charters? I don't know, going back to like Noble House, if you remember that case, and they were going to revoke the charter of the corporation. I'm just wondering if that was around the same time, the 16 legislature, I can't recollect. That's the only thing that pops out to me about issues on corporations and it's a Noble House case that I recollect from early 90s.
If you think it's safer to keep it in, we can also.
I mean, it doesn't hurt, I mean, to have that definition, you put it that way, I don't see why it's surplus.
So this is Christine Tenorio. So as far as subsection F, including the definition of corporation, I do recall, I believe it was Joe McDonald when he was chief prosecutor at the time. If I'm not mistaken, he used this statute to prosecute Prestige Auto for the, I think it was theft or something like that. And they had litigated it. And the reason why we were allowed to proceed on a criminal case against a corporation was because of this definition in part.
Oh,
That's,
Good
then we should,
pick.
we'll keep it.
Mhm.
good catch, Christine.
Yeah.
All right. We will strike it and keep it.
That's the only definition in 1.60.
Maybe the compiler can suggest a different location
There's-
for it.
This is Randy Conliffe. Section 4.80 is criminal liability of corporations. So I don't think that just by saying a person means a corporation when we have a section specifically designated as criminal liability of corporations.
Right, but I think the theft statute doesn't. It just says person, so
Right.
if you're gonna charge a corp, this covers it. At least for jury instruction purposes.
Mhm.
Really quick. Sorry, this is Jerry, the compiler. So the law that added it,
1684.7.
added a new section 2849.
Yes.
Every person who knowingly sends or causes to be sent or prepares obscene material. So they might have added person to include not just a natural person, but a business.
What are you looking at from?
Right here.
That's right.
You know, it added 2849.
I
So
see.
that might have been why they wanted to add a definition of person to include a corporation.
Is 2849 still viable? Hold on a second.
Yes,
So we should just keep it.
just
then.
keep it. Okay.
Yeah.
All right,
It'll look weird, but
We can put it somewhere.
we can put it somewhere
I'll
else.
find it. I'll find somewhere.
Okay, we'll unstrike it and keep,
so just to let you know, 28.49 on Title IX has been changed.
But the reason for adding
Right,
it
right.
was.
It was changed.
Yeah, but the reason for adding it at the time.
Yeah, I understand.
Okay.
all right then,
Keep that last section.
right, we'll keep the last section, subsection up. Okay, next slide, please, Jerry. Section 1.70, peace officer. Just to note that we did look at this, there are two main definitions for peace officer. One at 8 GCA 5.55 and the other in the post statutes, 17 GCA 51-101. We didn't find any indication of a conflict because of this definition of peace officer being used here. So we are recommending no change to this section 1.70.
I have a question on that. So when this was written and enacted into law, we didn't have a port police and we didn't have an airport police. And the laws that provide for airport police and port police say they are only peace officers when they are on the port property. So, you know, now that section now conflicts with the enactment of the statutes for the port police and the airport police, because it does say that they're peace officers, but their designation is limited by their enabling statutes. So when they're not on the police, they're not on the airport or the port property, they're not peace officers.
Ergo, they shouldn't be arresting people
Outside of the zones.
outside their physical jurisdiction of their.
Yeah, but I mean,
agents.
well, but in the use of this, peace officer has a meaning provided in 5.55, but 5.55 does not have the limitation that it just says that they're peace officers. It doesn't say they're peace officers when they're on their property. Now, maybe we just need to correct HECA section 5.55 and that would make it work.
That would, I'm looking at 5.55 right now, and there is a limitation. You're correct, Randy. I think it has to go there, but that restriction has to go there. You're right.
So you might want to note it in a footnote or something that 8.55 should be amended to limit the definition of peace officers for those two.
This is Phil Tydinko again, wasn't it argued, can't recall the case where an airport officer pursued. Hot pursuit. Airport into Harmon.
Yeah.
And did the arrest.
Yeah.
And the question I thought was he acting as a peace officer once he left the confines of the airport?
I recall
Proper.
the holding, I think it was allowed if it was a direct hot pursuit.
Okay, but, okay, well, all right, so that was how they carved it out case law wise.
Right.
I see.
Eight-
There is a decision out of the District Court of Guam that questions the viability of either a port police officer or an airport police officer acting as a peace officer off of the property, but it didn't reach. It just raised the question, and it didn't impact the decision.
Yeah, we'll make a note of it, and our subcommission under Judge Sakota, we're looking at Title 8.
Okay,
So when we get to that chapter 5, we looked at it already preliminarily, but we'll give it a deeper dive. We haven't reported to the commission on that.
You need to put a note on that.
Right.
The limitations being included. Mr. Khanna, thank you very much for the insight.
Okay, moving on to section 1.80. Definition of territory, we don't think this is necessary in light of one block with annotated section 4.20. And just for your information, I included that definition here. If you want to take a look at it. All right. Okay, next slide, Chair. All right, that's it for our recommendations for chapter 1.
one of them you gotta put down subsection F is.
Right.
kept.
Right.
Right.
We'll note that and make sure that we keep that out.
Okay, so before we proceed to chapter 4, is there a motion to accept and to move to the final reading file the suggested revisions, amendments, or repeals in chapter 1 as presented and after discussion?
I so moved.
Is there a second?
Second.
Thank you. Is there any opposed? There being none, it moves to the final reading file. Thank you. Let's be-
Okay, thank you, Mr. Chairman.
Okay.
Okay, we're moving on to chapter 4, general principles of liability. We do have some changes to suggest for this chapter. Certain parts might be better left open for discussion, and if any member wants to do a deeper dive into any of these sections, then we can table that particular section for that kind of further review. I'll note that I wasn't able to see, I didn't see any negative treatment of any of the sections in this chapter by the Guam Supreme Court. But if anybody here is aware of any, please let us know. For these sections here on the screen before you, 410, 415, 420, and 425, we are recommending no changes. Next slide, Chair. For 430 culpability defined, we are recommending no changes. Next slide. There we go. 4.35. The language that you see added, underlined, and then struck out here. We've taken this, going back to the NPC, and we looked also at the New Jersey statute. And we went back to the original language there. We noted and considered the possibility, though it might be a remote possibility, that the language that has been struck out, conduct, attendant circumstances, or result, might be elements without being material elements. And so we think that going back to the language, as you see underlined here, without distinguishing among the material elements thereof, just made it easier to understand and made less chance of a conflict. So in the comment, I put both for your review. We recommend striking the language that's struck here and adding the underlined language.
Does that restrict the application of the mental state to each element of an offense or crime? I'm just trying to understand what that means without distinguishing among the elements. Seems like it just changed the meaning. You said that's from the original
It's from the
NPC
original, right.
model penal code,
Right.
So in other words, if it's intentional, the old way, then every other material element, even if it did not require a mens rea, we could insert intentional. We would
Right,
add it, right?
right.
The old way.
Right, new way. That's what I'm saying, the new way
That was
kind of throws.
it doesn't require the insertion on the other material elements that don't have a
Right,
mens rea.
isn't there case law and jury instructions that have fought over that?
So as I understand it, what this actually comes from the model penal code and the New Jersey statute, the change?
Yes.
Yes.
I don't know where the language that's struck here, if it came from the original Guam Penal Code, but it didn't follow the model penal code exactly.
The sources include a tentative draft of California's code and Massachusetts, so it could have been from one of those.
Yeah, I tried to find that California draft, but I couldn't find that anywhere. Yeah.
No, right. Now distinguishing among the material elements thereof. So my only concern, and I this is above my only concern is that the way it's proposed to be written, does it now not require a mens rea to be
That's why I'm.
artificially inserted in the other material elements if not stated already? I know that's not the way to say it, but trying to think of a practical application is still.
I mean, the jury instruction is that the elements apply to, the mens rea
Apply
apply to
to
every
each
element.
element, right? That's mandated by A, but if you take it out,
Does it change?
Does it
That's
destroy
what
it?
that's what I'm asking. What do you think, John?
Still trying to
Understand
appreciate the difference.
Me too.
I feel like somehow the difference is going to get lost among the people who are trying to apply this, because I'm trying to figure out how this would play in jury instructions. And what does it mean what does the phrase without distinguishing among the material elements thereof mean? The issue is that when you go through the essential elements of a crime, the way it's delineated in jury instructions, every phrase is a central element. So I feel like this makes it more confusing, because really the mens rea only applies to, if someone says engage in this conduct, then it only really applies to that you intentionally engage it in the conduct, unless there's an attendant circumstance, like for the purpose of this. So did whoever researched this, were you able to, was there like real life applications or like that examples given from these jurisdictions of how this would affect how this comes into play?
I didn't see any.
Yeah, this is Randy again. So, yeah, I'm looking at this and I'm wondering if you just left out all of the red and it just said if the definition of an offense prescribes a culpable mental state, the prescribed culpable mental state shall apply to each such element, each element.
I mean, that's how we do the jury instructions,
Yeah.
right? I mean,
Yeah.
You know,
That's how we do the instructions, but
I mean, I don't think there's any crime that jumps mental states within elements.
yeah.
I think there's a lot of discussion. We should probably table this for God.
Yeah, at least to find out wherever the language, the jurisdiction that uses without distinguishing. As well as the one that says, but does not specify the conduct, I just never paid attention to the but does not. Yeah, as Randy said, we always just go with prescribed mental state, and the prescribed mental state applies to each material element. And that's how we always craft the jury instructions. But yeah, we should probably table it.
yeah. Okay.
Because right now, even without the proposed change, we do it the way we're all talking about right now. With that, does not specify phrase. You know, so
Okay, that one's tabled.
yeah, okay, good.
Table that one. Thank you.
Okay. 4.40 culpable mental state generally required. We have no changes to recommend. Next slide, Terry. 4.45. So what we've done here is we are clarifying the title. The original title was 4.45 same when inapplicable. And the word same is used actually it was inserted by the former compiler to refer to the previous section.
Yeah.
And so by inserting what the previous section actually was entitled, dealing with culpable mental state, we think it provides a better title for the section without taking an abbreviated, well, without giving it an abbreviated title. In the language of the statute itself, we are suggesting the change that you see here, striking out purpose to dispense with any culpable mental state requirement and inserting legislative intent to impose strict liability. And this was taken directly from the Model Penal Code in New Jersey. Also, to make it consistent with 4.45 A2B, which you'll see in a subsequent slide, which actually references expressly strict liability.
Well, you know, when you leave it up to legislative intent, you're going to be litigating the legislative intent. If there's no clear legislative intent, which with our legislature there usually isn't, then you're not going to get any strict liability. But if you leave it with the existing language, and I think that I found one or two statutes that specifically dispense with a culpable mental state, that makes it pretty simple to apply. But if you're going to try to apply it to a legislative intent, it's going to be litigated to the Supreme Court all the way. I mean, until they decide it.
I agree. I think one of the statutes this has come up with is the leaving the child unattended in a motor vehicle. It actually, the way it's written, it is really strict liability because there's no mental state in there. But if you actually go to there is no legislative intent that says individuals who leave their child in a motor vehicle you know, we want this to be strict liability. They just didn't put a mens rea, and then it ends up strict liability. But if you change it to the way it's written right now, we're just not gonna have that. Yeah, like Randy said, it's just gonna be litigated all the way.
So keep it.
Mr. Clement, Randy, do you remember, I can't think of offhand right now, a statute that doesn't, a strict liability statute that doesn't, I mean, I can't think of a strict liability statute.
There is, and I know that I didn't look at it before I came here this afternoon for this, but I have researched this in the past, because I'm the kind of guy who will raise this on appeal, or at the trial court level. I mean, you know, technicalities are what you win 25% of your cases on. And so I look for every technical issue there could possibly raise. And if there's no legislative intent in the discussion, then, you know, I think there is one or two that says we actually dispense with a culpable mental state, or we want strict liability is written into the statute.
I think, this is Jerry Cepeda, I think the issue, being the person who reads all the legislative enactments, is finding something that says clearly indicates legislative intent. Because there will not be, as Attorney Cunliffe noted, there won't be something in the statute that clearly indicates legislative intent regarding strict liability. Even in the case of the statute that Attorney Tenorio mentioned, although it's obviously strict liability, when you read it, there's nothing indicating clear legislative intent in the public law that enacted it.
Correct me if I'm wrong, this is Jonathan Kwan. I believe there's a subsequent statute that requires that if there's no mens rea stated, recklessness is automatically inserted. Am I did I get that wrong?
That's right. That's the fallback.
All right,
The default,
right.
the default provisions we're talking about.
So I can't think of it, and I'm sure right, but I can't think.
Strict liability requires legislative definition.
But I can't think of any that we have on the books. I'm sure Randy's got it too, but
But I think Christine was saying, what about the statute that's
Minimum-
simply silent?
minimum reckless based on,
Well, yeah, it should be minimum reckless, shouldn't be strict liability, right?
right, based on I can't find the
But-
section right now.
Right, so this came up with the leaving unattended child in a motor vehicle because this is what Mr. Vandeveld had argued. All the statute says is that you leave your child in the motor vehicle, but you know, we were arguing you can't impute recklessness to that because you don't recklessly leave your child there, you just do it. You just leave your child there, and there is no mens rea in that statute.
Did the court rule on the issue?
I think he did. It's expunged now, but Judge Canto at the time, I think he did rule on the issue. And I can't forget, I don't remember what it was, but that I'm just saying that was like the interpretation. And whatever the ruling is, we still go by, we actually think that it is strict liability. So if we ever charge someone with that particular crime right now, we don't say you recklessly left your child in a motor vehicle.
I actually, this is Assistant Public Defender Brian Eggleston. It actually makes me rethink a provision that we looked at just a couple moments ago where we were talking about replacing attendant circumstances and outcome with just material elements. I think actually this may in fact raise why having the list like attendant circumstances is preferable, because at least I think the example of the leaving a baby in the car, when we talk about it in terms of outcome or attendant circumstances, we can make sense of the culpability requirement to say the person needs to at least be reckless with respect to the circumstances that the child is in the car. You know, if someone reasonably believes the child to be elsewhere, I think it would be a defense. But so I think having it actually talk about whether we're talking about result or attendant circumstances helps to actually explain what the culpable mental state is referring to.
I see. So you're talking, an example would be the defendant thought somebody was there with the child or that the child was gone. It was reckless, it wasn't correct, but they thought it. And then subsection 4.40, the culpable mental state requirement sets the floor at reckless. I see. I see what you're talking about.
Any
Right,
will satisfy.
But the floor is always reckless.
Yes.
Mhm.
So is the preference to keep the language?
I don't,
I would vote to keep the language and not change it to the indicate a legislative intent.
I
I'm
agree.
gonna agree.
Me
I'm in
too,
agreement.
me too.
And then moving back to 4.35, keep the original language there as well.
Yes.
Yes.
Yeah, then it kind of works together.
And it makes sense with the car, baby in the car thing. I see it. Okay.
Okay,
And I just wanted to raise one last thing regarding 4.45. I think that the change in language there actually includes two different changes that could be adopted separately from each other. I think actually now that I look at it, I agree with keeping purpose instead of legislative intent. The other change that occurred in the language though is replacing to dispense with any culpable mental state requirement with to impose strict liability. So I think that actually could be independent of whether we change purpose to legislative intent. I'll say I actually think I prefer dispense with any culpable mental state requirement, but I just wanted to raise that that change could be made independently.
I mean, you're gonna have to go back, because I think there are some statutes, and you'd have to go back and change those statutes if you change it to strict liability.
Yeah, you would.
You would.
And the actual, I think what actually motivated this whole recommendation in the first place was that a section or two later, there is a statute that refers to strict liability. And when I hit that, I realized that there was nowhere else in the code that the strict liability term was used. So it was essentially undefined, leaving kind of that later provision unclear about whether strict liability is intended to be coextensive with 4.45.
Jerry, could you go to the next section? It's there.
Yeah.
Strict liability is in
A2B. Yeah, that's right.
it's colored blue. This is where it's referenced expressly.
Yeah, but I don't recall a crime with that element spelled out.
4.50.
Three's in the next.
Wait, did that change?
He's putting it all in,
It's putting it in.
all together.
I see.
So this should be.
I see.
Yeah, the formatting is off. I apologize for
Supposed to
that.
be B.
And then 3, yeah, B3.
Right.
Okay, I see it.
The formatting is glitched when I converted from PDF to PowerPoint.
So the only suggested change is just probably to probable.
Yeah, that's just a grammatical correction.
Okay. Okay,
Okay,
I have no objections to that. Anybody have objections?
all right, moving on to 4.55, 60 and 65, no changes recommended here. Next slide, please. 4.70, just a slight correction to the title of this section, make it a little easier to understand. And for 4.75, the same thing as we did above to better explain the title.
Let's see.
This is Jerry. I encourage all the subcommissions, when you run across same, to do this.
To actually explain that.
To actually go back and see what is the initial section name for the sake of clarity. Thank you.
Next slide, Jeff.
No change then.
Okay, 4.80. Criminal liability of corporations, no changes here. And that is it for the recommendations, Mr. Chair.
All right, at this point, we've had some pretty in-depth discussions. Is there a motion to accept the subcommission's proposed changes, amendments, repeals, and no changes after taking into account what we agreed and disagreed to here? Is there a motion to accept it?
So we're leaving out the one that we tabled?
Yeah, for the ones that we were talking about tabling, 4.35 and 4.45, we'll make no changes and keep the original.
The originals.
Okay,
Is there a motion?
I so move.
Thank you. Is there a second? Thank you. Any objections at this point? Being none, let's move to the final reading file. All right, I want to thank Chair Secola and her subcommission for the quite a bit of work, although it was a limited number of statutes, the amount of thought, the amount of theoretical discussion that must have happened in there was quite extensive. I want to thank you all for your work. At this point, any other issues on that? Okay, let's move to the next slide. The next plenary meeting is tentatively scheduled for Thursday, June 6th. June 6th at noon. Go back to slide 32, number 32, the agenda.
Oh, the agenda.
The agenda. Finally, on item number 7, I have no communications to present. Other than the letters we sent out to the various agencies requesting their reviews. And under item 8, are there any comments from anyone?
Mr. Chair, I just want to mention, although she's not here, our management officer, Valerie Cruz, is retiring. Oh, effective tomorrow. Oh, and I wish she was here today, but I think she's busy getting ready for her retirement, running around and doing what's necessary for that.
With a huge smile on her face.
So I do want to recognize her and thank her on the record for all that she's done in helping the commission get started. She was with us since the very beginning. Renee will be stepping up and doing everything that Valerie's doing or has done, and that our work will just continue uninterrupted. So that's all, Mr. Chair.
We'd like to thank Valerie Cruz for what she's done. And Renee, you have some big shoes to fill. I'm sure you'll do fine. Thank you. All right, at this point, there's no other business or discussions. I want to thank the subcommissions for what you worked on. Please continue. There's not much time left on the clock. And we've got a good head of steam going on here. So thank you, and please continue to chug along. That being said, is there a motion to adjourn?
Move to adjourn.
Second. Any opposed? There being none, thank you all for your effort. Monty. Thank you all for your work.
Thanks, guys.